I will talk about access to territory, one of the issues I think being key to what I would call at this moment not in my backyard asylum, which means that everywhere from Austria all the way down to Greece and even beyond to Turkey, we see the same mechanism. Because Turkey thinks that Iran is a safe third country. And how far do we want to go until we get right down to the bottom? As I said, keep in mind I will end on a positive note, but that is something that we will have to look into. The EU-Turkey deal, I'll talk about that. It's a statement. It's not more than a statement. Is it a legal act? I've never heard an academic say that a press statement is a legal act. Why is there not lengthy discussion about that issue? That is something I think which is important to remember. And we'll talk about the safe third country concept and how it works out in several countries. I'm involved in litigation against Macedonia, Hungary, Serbia, and Spain, just to name a few countries. And I'll be talking to you a bit about the cases which are running and the challenges that we are facing as lawyers. Obviously, I'm here from a practitioner's point of view. But even as a practitioner, I'm fully aware of the challenges that authorities face with, or have faced over the last year. Access to asylum, naturally, and the asylum procedure and all that it entails also is an issue which I think we ought to look at. And I probably don't get down to the reform of the Dublin system, but I'm keeping that on my overview just as a challenge. Right, access to the territory. Remember that under the Geneva Convention, the drafters of the convention never envisaged such a complex legal structure that we have come to work in nowadays. 33 in all its boldness is also quite simple. 33 of the Geneva Convention. It is applicable obviously to asylum seekers who have been granted asylum, but it's also applicable to those who are still in the process of asking for asylum. Now, after the Genevan Convention, we also historically had the European Convention on Human Rights, the case law involving asylum, and then the new kid on the block is obviously the EU Charter. And I've just put up a few articles. I mean, everything will be in PowerPoint, you'll be able to read it, so I'm hoping that I can just draw your attention to what I'm talking about. And these are just a few slides to help you with. Right, why is it important to see that the Charter is of crucial importance in the asylum procedure? Because with the Charter comes all of the EU law, and with all of the EU law comes a wealth of information and a toolkit to use. We strive to make asylum more simple. With EU law, I think it's become a lot more difficult, a lot more complex, or challenging for us lawyers. Article 18 is the first article where it says there is a right to ask for asylum. Why is that so important? Because it means that admittance onto the territory of the country means the right to ask for asylum and everything which is involved in that. The Charter's got two other articles, 19, or besides 18, Article 19, the prohibition of collective expulsion. One of the first cases prior to the Charter was the Chonka versus Belgium case. It was a group of Roma being collectively expelled. And I'm just highlighting a one-liner out of that decision because it says that collective expulsion means any measure compelling persons as a group to leave. Any measure. It doesn't, in other words, you can take any measure and you can challenge that under the Article 4, Protocol 4 of the European Convention. And after that we saw the Hirschi case, which was, I suppose, from a legal point of view, quite easy. Because these were asylum seekers, they were on an Italian boat, so were de facto and de jure under Italian jurisdiction. And even though if they weren't on the territory of Italy, they were on the Italian boats. In other words, there was jurisdiction. It's important to see that after Hirschi we've seen the Khalifa case and several other cases whereby I suppose asylum is expanded all around to where a country has jurisdiction. If we tie all of these three legal orders together, Geneva Convention, the European Convention on Human Rights, and the EU law, or CIAS, we see them working together. For example, as I said, the Hishiyama case against Italy, which is for February 2012, the court already considered that the events giving rise to the alleged violations falls within Italian jurisdiction. And it's important to remember that Article 1 of the Convention should also be cited, because it says the very basic idea that the high contracting party shall secure to everyone within their jurisdiction. Now think about that. If you've had a case called Jaloud versus the Netherlands, whereby the Netherlands was being held accountable for acts being done by Dutch troops in Iraq in a peacekeeping mission, I would not be surprised that if one of these days we will see groups of asylum seekers outside of their own country fleeing towards a contingent of Dutch, English or European armies, saying, you've got jurisdiction here in this area, and we're going to ask for asylum, for example, in Mali, because we are from Niger, or we're going to ask for asylum in Iraq while we're from Syria. You know, just hypothetically supposing that people would be coming there, and I would gladly help them challenge this issue, obviously. But it does become important. I'm just giving you this idea to make sure that access to asylum, access to territory is an expanding idea. And we haven't come to the limits of that yet, I think. Particularly if we look at asylum in combination with Article 4, Protocol 4, the prohibition of collective expulsion. Right. I am assuming, because I wasn't here yesterday, that you talked about the EU-Turkey deal in great length, or at great length. The legal basis of that has already, I presume, been discussed with you, and I'm sure Kees will have, Wouters will have covered. No, you haven't talked about that at all? Tino talked about that. Oh, yes. Well, I think it's important to remember that Article 38 of the Procedures Directive is quite clear. And so far, I think we've seen a rather disappointing use of that in the cases that I'll talk about a bit later. Why? Because there has to be an individual assessment of the safe third country, and an assessment of the connection between the applicant and the third country concerned. And all of that we have seen is happening at a rather abstract level. You have traveled through that country, thus there must be a connection. This is what people are saying, or this is what the authorities in Greece are saying towards Syrians and non-Syrians traveling through Turkey. And the same mechanism applies in Serbia and in Hungary and so forth. Well, if we look at 38.1, it is quite clear that there must be a connection and a certain quality of this connection. And so far, the European Court has not seized upon the opportunity to rule on this. Well, given the fact that we've seen a clear interplay between Strasbourg and Luxembourg courts, and Strasbourg courts using Luxembourg legal instruments to give their considerations upon, I'm sure that one of these days we will see the court reacting to that. Safe third country from an individual's point of view means also procedural safeguards. It means a personal interview, an effective remedy, and under Article 10, can I draw this? Article 10 of the Procedures Directive says it must have a due diligence. Due diligence. I think next door they're doing corporate law. They know what due diligence is. I suppose we all know what due diligence is. It must mean that the decision making, based on whether there has been an individual assessment or the connection between the individual asylum seeker and the third country, has got some quality. It should be objective, it should be impartial, and it should be a thorough investigation. And so far we have seen quite a few countries which have tried to play all of these safeguards down. And now, now they're in court in Strasbourg, which is my next slide. Disappointingly enough, one could see that so far there's been very little preliminary questions asked to Luxembourg, which is strange because all of this are part and parcel of the EU. We as the EU should not overburden the already overloaded court in Strasbourg. I'm sure that you would agree with me on that. Yes, I can see a thumbs up on this issue. So why, if we see what I would call trickle-down asylum, in other words, from Austria to Hungary to Serbia to Macedonia to Greece to Turkey, all the way down the stairs, why aren't we seeing any preliminary questions raised in this issue? And I was at a conference yesterday speaking to a few judges, and all of the judges are saying, well, if we ask these preliminary questions to Luxembourg, it will take at least 15 months, and what are we going to do with all of these cases in the meantime? Yes, it's a perfectly valid argument, but it also means that there's no, there's no évolution, there's no evolution in this case law at the moment, and I think it is needed, because if we look at the practices which are going on at the moment, they're simply not on. And I'm going to do a bit of Hungary bashing. I'm sure there are going to be Hungarians here, and Serbia bashing, and Macedonia bashing, and Greece bashing. In other words, everybody get bashed. Again, remember, at the end of the morning, I'll have an Indian summer for you. This case is currently at the European Court, and the case will be, the full application will move on and has been moved on, and we're waiting for the court to react. It involves two Bangladeshis. Their asylum procedure in Hungary, they arrived from Serbia into Hungary, were placed in the containers, the sea containers at the border, spent several days there in a totally cramped situation, in a situation which I would call sub-MSS. If you remember what MSS is like, this was sub-MSS. They were fast-tracked through the procedure, Hungary basically saying, right, they can go back to Serbia. On the 8th of October, a decision by the court was delivered, and this was the Hungarian court. Now, the police and the immigration authorities visibly pushed the applicant, it says rushed, but it should be pushed, the applicants to leave the Röszke transit zone in Hungary immediately. I'm just focusing on this last bit. There's a whole story before that. And while awaiting in the pre-transit zones, you have a transit zone, a pre-transit zone, and you even have a little zone before that. It's a weird legal construction, but anyway. The Serbian border police informed the applicants that they were not allowed to enter into Serbia without official documents. So they were stuck between a rock and a hard place. That was quite clear. And only after close corroboration between the UNHCR and an NGO, the applicants were allowed to enter Serbia on the green side. I'm highlighting that just to illustrate the manner in which in the EU at the moment and outside of the EU, in the Council of Europe jurisdiction, we are treating asylum seekers in such a way. What happened to the right to ask for asylum? You know, these are, I think, very important issues. Now, after they were expelled on the 10th of May, the applicants were once again waiting in the informal camp to be admitted into the entrance into Hungary. So they're still stuck there. 4 days later, they were allowed to enter a police station, finally, to express their intention to ask for asylum. Remember, these people still haven't asked for asylum there. You know, they're still waiting. And the police told them to go away. And the police told them they don't have a right to apply for asylum in Serbia, which is quite strange, because the Serbian asylum law, which Serbia having aspirations to join the EU is based on SIAS, clearly says that they have the right to ask for asylum. But this is, again, a visible example of not in my backyard asylum. Go away, go away, go away. That's all they're saying. And the police officers informed them that they have no right, and the following 6 days they were forced to reside on the streets of Belgrade. And only after an intervention of the Belgrade Human Rights Center lawyers were they allowed to receive certificates concerning their intention to seek for asylum on 19 May. So in 9 days, they've taken a tiny little step, the intention to seek for asylum. Now, how long can you keep asylum seekers waiting on your territory before you ask for asylum? And if you think Serbia is bad, Spain is even worse. Spain has got these very small enclaves on the Moroccan territory, or near, no, not on the Moroccan territory, near to, oh, sorry, I wouldn't dare to say that. They're called Chita and Bahia. You can play golf there, it's really good. If you don't play golf, or if you do play golf, you might see that there are big fences there. And in these fences, there are people stuck. I'm putting the communicated case up just for you to get an idea of what's happening there. The first applicant was able to climb on top of the third gate and hung there until midday without any legal or medical assistance. The second applicant was hit by stones. Stones thrown by both the Moroccan and the Spanish border guards. I thought kids threw stones, not border guards. But eventually managed to reach the third gate. And meanwhile, they witnessed the violence of the Spanish Guardia Civil and the Moroccan security forces against the other immigrants. After 14 or 15 hours, they came out of the third gate with the help of Spanish security services. And after they put their feet on the ground, they were stopped by the guards who returned them again to Morocco. At no time did they have access to an identification procedure, and they did not get the chance to explain their personal circumstances, and received no assistance from lawyers and interpreters. 14, 15 hours later, and only after 14 and 15 hours did they discover that of these 3 poor asylum seekers, one had broken his leg. He'd been hanging on a gate while probably one of my rich uncles was playing golf for 14 and 15 hours with a broken leg. This is what is happening in Europe today. It's not comfortable to hear these stories, but on the other hand, we can't close our eyes to this situation. Greece. I hadn't done any Greece bashing yet. I think it's important to see that in the access to asylum, the court is quite strict towards countries which do not play by the rules. Now, Mr. A.Y., he had worked for the Americans. He was an Iraqi who had worked for the Americans for quite a long time. He could prove that. He was the ideal asylum seeker. Why? He had a passport. He had all the documentation proving that he'd worked for the American authorities. And he asked for protection, which I think is quite normal. However, he was not allowed to ask for protection. The court noted that specifically in, I think, was it paragraph 6. And instead of allowing him to ask for protection, his expulsion was ordered. And the Greek authorities said that he may have asked for asylum, but they never registered it, so it doesn't count. Where does that come from? I mean, you know, we're talking 2015. Where does it come from that suddenly, as an asylum seeker, you ask for protection, but hey, if we're not going to register it, it doesn't count? I mean, that kind of situation is just totally unacceptable. The Greek Refugee Council demanded that they actually register his asylum request. And also, he was held in a detention center, which was bad, but it was for 45 people, and there were up to 200 people there. That's 5 times as many. And he spent between October 2010 until January 2011 in detention. So that's 3-4 months for a guy with asthma, and still nothing had happened. The court was quite clear. The court considered in this case that the applicant, with his documents, had proven a prima facie risk and thus arguable claim. Why is that important? Because with a prima facie arguable claim, Article 13 kicks in, and with 13.3 kicks in, and all the qualities which should determine the asylum procedure in this issue. Now, the authorities were found to be in violation unanimously on Article 3 and on 13 in combination with Article 3. And the authorities had not sufficiently checked what happened to the asylum request itself. And the court made a note of that. You know, in other words, you can't just say, all right, you can sign something and we're not going to look at it for any further, and then expect to get away with it in Strasbourg. And again, this is a situation, and I'll just put MSS underneath it, because now we're 4 years on. Now everybody can say to the Greek authorities, oh, you're doing such a bad job of it. But remember, the Greek asylum procedure has never worked. Has never, ever. The Greek asylum system has failed even before it started. So it failed before 2000. And now we're nearly 20 years on. We're still doing Greek cases. You might have discussed yesterday the question of starting Dublin returns back to Greece again. Somebody had that great idea. And then relocating them from Greece back to the north of Europe, like we're trying to do that in Italy. And then you come back to my title, which was the Asylum Carousel. You understand what I'm talking about, and I call it the Asylum Carousel. It is, I think, a waste of everybody's time. Just another issue which I think is very important to remember is that the court has been quite clear since the TI decision on what what authorities should do. They cannot rely on safe third country concepts without looking at the case properly, which means also looking at the situation in that country where you're sending people to. I think the Mirza decision, is it here? Yeah. Sorry, I'm bad at making PowerPoint, so it's like completely different layout and so forth. But Mirza is a case where the court said it's perfectly fine to send an asylum seeker back to a receiving country, even if you know that the receiving country applies a safe third country. The only thing that is important is that you've got to make sure that this safe third country is applied in a proper manner. The court did not say that Serbia was safe, which was a misunderstanding, which was encouraged by the registry of the Luxembourg court by saying that was the gist of the decision. It wasn't. The court only said it was for the national authorities to decide if a country was safe, and it was not going to rule on this issue because it wasn't asked a question about that. Right. There are two cases which I would like to put up, and which is important in this issue. And these are two cases, sub-TI versus UK. TI, you know about, it's the case Reunited versus France. And it's paragraph 103. Sorry, I'm making an entire mess of this. And there's also a case called O versus Italy. I will put them up later and write it down, nice handwriting, in which the court ruled on the presumption of equivalent protection, which is a legal presumption. The legal presumption being in that country where we're going to send somebody to, there are so many safeguards that they'll be perfectly fine, and we can do this in a fast-track procedure. The court was quite clear that, yes, you may apply that, and you may apply legal assumptions that some countries are safe. But these legal assumptions can never be absolute. And that was, I think, the Sum by the Youth decision by the court, which said, legal assumptions should also be rebuttable. So if you're going to send people back from Hungary to Serbia and from Serbia to Macedonia, you should look at country of origin information to determine whether the quality of usually the quality of the law is not the problem, it's the practice which is the main problem. This is, for example, a very recent case where an interim measure was issued. It concerned a Darfuri applicant from Serbia to Macedonia. Now, if he were to be expelled from Macedonia, he will be subject to an Article 3. And he will not have access to the asylum procedure in Macedonia. He will not have access to services that satisfy the basic needs, in other words, MSF situations. And he will be at risk of ill treatment by the police, and he will be at risk of deprivation of his liberty. In other words, All of this is based on the UNHCR report of August 2015. And this is one of the first examples where the court, the European Court in Strasbourg, has issued a Rule 39 on the 4th of October. And the case has to be in the court by the 1st of November. So it'll be very interesting to see if it is communicated. I would assume that given the fact that, again, this is a prima facie asylum seeker, you know, Darfur is practically a 15C situation for certain tribes, to see if it is communicated, and I would assume that it's not dismissed by a single judge chamber in Strasbourg, but that's my assumption, and we don't know what's going to happen. And what will be interesting to see is whether the court will ask questions towards Serbia and probably also towards Macedonia. And why is it important? Because, hang on, yes. There's been two very important cases delivered by the court, Grand Chamber cases called GR and JK versus Sweden. And they are on the burden of proof. And in both of these cases, the court was quite clear to set out the homework for the national authorities to do. In other words, we're going to explain it to you once more how you do the burden of proof in asylum. Correct me if I'm wrong. If I'm too enthusiastic, you can say, yes, young man, but that's not how we really thought about that.
You're taking all my punchlines, actually.
Oh, sorry. Sorry. But the JK, I think it's important to bring back what's happening in the safe third country debate, bring it back to the basics, because it's already difficult enough. And that is, if there's general information, then you have an obligation to investigate it, particularly because you, as a government or national authorities, have a far better information position than the individual asylum seeker. Yes, the individual asylum seeker should always bring forward the information relating to his personal situation and bring forward evidentiary proof or medical proof or what have you not about his individual situation. But with regard to other countries or situations in other countries, the governments have a proprio motu obligation to investigate and to assess it. This is logical, but it also means that there are a lot of more safeguards before you can use the safe third country or the first country of asylum against an asylum seeker. Tarankel. All of you know the Tarankel decision. It's important to see that since Tarankel, we've seen the court, I'm going to do a bit of court bashing as well, somehow having the notion that if we give Tarankel, and that people actually try to use Tarankel before being sent back to Italy, which is completely overburdened, we, as the European Court, suddenly get into a situation which was similar to the KRS situation. This was the KRS versus Greece, Dublin situation, whereby the court had hijacked itself by accepting presidential degrees by Greece. Similarly, at the moment, the court is being hijacked by the Italians about this so-called circular letter. Everybody has heard about this circular letter. And the court will probably get itself hijacked by the comfort letters with regard to Turkey. It is up to the court, and I think it's very important to see that the court looks at as a matter of legal consistency at its own case law with regarding Article 13. Rights which in theory are beautiful, but in practice are not effective, are not real rights. Rights to reception conditions in Italy, which is completely overburdened for Tarankel families, which are not effective because they won't be able to get to these rights, are not rights which are on. Yesterday, the court gave a Rule 39, and I'll put them up, for a Tarankel-like family which was to be sent from Austria to Croatia. Why? Because Austria had not done its investigation. So again, this is an issue which will come up time and time again. It's a case called O versus Austria. what we see is that the court keeps saying, what have you done as far as an investigation is concerned? And it is allowed to do so because it doesn't have the circular letters that we have with regard to Italy, or the comfort letters that we have with regard to Turkey. And in the situation of the lack of written guarantee, the court feels free to use Tarankel in another situation again. So, it will be very interesting to see how this case plays out. So that's the O versus Austria case, which is now running. Yes, Babayanov versus Turkey. Babayanov versus Turkey is a case whereby the court was quite clear in saying that even if in the past the European Court has, that you have said that for certain asylum seekers Iran is a safe country, it doesn't per se mean that for every asylum seeker Iran or Uzbekistan is a safe country. And the court wasn't very much concerned, if you look at these paragraphs, about the fact that Turkey hadn't done any investigation into Article 3. Why? Because it said that regardless of what we've done and said in the past, the Turkish authorities should have carried out an adequate assessment of the applicant's claim that he would have a real risk in Iran if returned to Uzbekistan. So what we see in this Babayanov case versus Turkey is the court taking a procedural review, not a substantive review, on what's happening in Turkey. And I just put up a more recent case, the RD versus France case. I'm just putting it in quickly. Why? Not for, it's a female mutilation case, which is not the reason why I put it, I would draw your attention to it, is the fact that fast-track procedures can be used, there's nothing wrong with that per se, as long as asylum seekers have sufficient time and knowledge of the asylum procedure and what to put forward individually. And it referred to the old cases, IM and ME versus France. France is a big lover of fast-track procedures whereby procedurally they don't allow the asylum seeker to do much and to have his say. That is not on. Because in order for you to fulfill the conditions in an asylum procedure, to bring forward an credible asylum motive and to bring up proof, the asylum seeker should first know about this. And if he doesn't know what he's supposed to do, and he doesn't have legal assistance, then we will see quite quickly the court being quite strong and vocal on this issue. And that's why I put up the RD versus France case. I'm coming to my conclusion now. It is quite clear at the moment that with all of these safeguards and all of these legal instruments and standards to live up to, governments face serious challenges, and 2015 was a challenging year, to put it diplomatically. And it is important to note that if the governments are doing their best, but are at this moment seeing limitations in what they can do given the mass influx, there's also possibilities for civil society to help out. Now, I'm going to show you a little film in a minute, and that's a private initiative of several lawyers and journalists and NGOs to help children. At the moment, 10,000 children are lost in Europe, UNICEF says. That is not acceptable, 10,000 children being lost. Now, a lot of them, and I've been in the Balkans, I've been in Greece, I've been in Turkey, I've been in Italy over the last half year, and all of these 10,000 of children, at least half of them, 5,000 children, have got parents in the north of Europe. Now, I don't know whether Minos has said, or other people from the Greek authorities. The Greeks are doing a great effort to have the pre-registration done, so at least they know who they have inside their house. Now, what needs to happen is for Northern European countries to accept that if their parents have got an asylum status in their country, then they should get these kids to their parents before Christmas. And that is possible, because the Greeks have invested greatly in the Dublin take charge situation. It's now up to the Northern European countries, particularly Germany, Austria, but the Netherlands and all the other countries, to accept these asylum seekers. And because at the moment countries are not reacting quickly enough, and it's the aim of this Kids Reunited to reunite, they are pledging several organizations to help and reunite these children back to their parents before Christmas. And now I can show you, hopefully, is it this one?
Meet Khadija, recognized refugee from Syria, in Holland. And this is her son Mohammed, in Greece, more than 2,000 miles away from his mother. He's just turned 18, but his 4 siblings are 5, 7, 13 and 16 years old. They haven't seen their mother for more than a year. They are 5 out of more than 3,500 children in Greece alone, registered as unaccompanied minors and legally entitled to reunification. Conservative estimates by UNICEF say that 10,000 children in the EU have disappeared altogether. This is unacceptable in every way. Kids Reunited is a pro bono collaboration between lawyers, journalists, civil society and NGOs working for the rights of children and asylum seekers. Together, they work case by case to reunify children and parents. In doing so, Kids Reunited creates space for governments to perform their core tasks, arrange for reunification of all children and speed up that process, and combat human trafficking and child exploitation. Khadija and her children are back together now. How long will other children have to wait?
We talked about simplicity. It's very simple. We're going to send people to Greece, Italy, Balkans. We're going to register these children. We're going to get, on behalf of these children, the national authorities to put forward take charge Dublin requests. It's very simple. These Dublin requests will end up in your respective Dublin units. The only thing we're asking the governments to do is to act swiftly and to make sure that they accept these Dublin requests in order for these kids not to be exploited by organized crime, but to come to Europe in a fashionable, or in a way which is respectful for the rights of the children. In other words, with a visa, with a plane, and they will be reunited again. And I'm really hoping that with all of us here together today, we can make a difference, because I think these children at least deserve the right to be with their families. Thank you.